From Studio 226 in Orlando, this is Aging Smarter. Aging Smarter is a podcast focusing on making it easier to grow older, to prepare for the future at any age. We aim to educate, entertain, prepare, and amaze you about your life's journey, regardless of your age. From the moment that you're born to the moment you die, you have been aging. It's the one thing we all have in common. I'm your host, retired and former circuit judge, Jose R. Rodriguez. I know that's a long tongue twister, but hey, you know what? Jose R. Rodriguez. I won't make you roll your R's. All right. So what we're going to talk about today is about physicians' orders for life-sustaining treatment in Florida guardianship. That's a long title, and it's kind of a tongue twister. In this episode, we'll walk you through how the physician's order for life-sustaining treatment, we call it POST, is Physician's Orders for Life-Sustaining Treatment. Orders and how they operate within the frame of Florida guardianship law, especially when it comes to incapacitated or terminal wards. We'll cover what POST is, how Florida law handles them, statutory safeguards, and how it interacts with Chapter 744 of the Florida guardianship law. I know we're going to talk a lot about law, but you know what? We're going to try not to make it too boring because we don't want to lose you. So let me introduce you to our guest. Our guest for this podcast is Mercedes Da Silva. Mercedes is a law student at Barry University School of Law, and she's a candidate for a Juris Doctor degree in 2026. In other words, she's kind of in her last year, so hopefully she's got a lot of research behind her. Welcome, Mercedes. It's a pleasure to have you here, pleasure to work with you, and to help me explain what the acronym POST is all about, Physician's Orders for Life-Sustaining Treatment, and what that means. Also, how can those relate the wishes of a terminal patient to doctors and to loved ones in their final hours? So, tell us a little bit about yourself.
Hi, my name is Mercedes Da Silva. I am a 3L at Barry Law. I'm a senior editor for the Child and Family Law Journal.
Excellent.
Yes.
That means you work really hard. The old saying about law school is the first year, they work you to death. No, actually, they scare you to death. Second year, they work you to death. And third year, they bore you to death. We hope we're not doing that, but I can tell from all of the things that you're involved in that you're not a show horse, you're a workhorse.
Thank you very much.
Tell us more.
In real-life clinical settings, end-of-life decisions often emerge during moments of crisis. A patient may lose capacity suddenly, and clinicians must make immediate decisions about their care. POST is a vital tool in these situations. It turns a patient's treatment preferences into actionable medical orders that are respected across different care settings. Unlike an advance directive, which outlines general wishes for care in advance, a POST is a medical order that is immediately executable by healthcare professionals. POST helps ensure that the patient's wishes, especially when it comes to life-sustaining treatments, are honored quickly, even in emergency situations. When a ward or a person under guardianship loses capacity, guardianship law plays a crucial role in ensuring that decisions made about POST align with legal protections. This ensures that the ward's rights and dignity are safeguarded with their rights.
So, how does Florida handle POST, Physician's Orders for Life-Sustaining Treatment? How are those orders treated?
In Florida, the POST paradigm is supported by the Department of Health and is commonly adopted in clinical settings. However, it's distinct from the advance directive framework outlined under Chapter 765 of the Florida statutes. POST is designed to be a more immediate and actionable medical order, particularly in situations where a patient is critically ill or incapacitated. A POST order or arrangement is completed by a physician or other qualified clinician in consultation with the patient. If the patient lacks capacity, or it can be done through their surrogate or healthcare proxy. The purpose is to document preferences about life-sustaining treatments such as resuscitation intubation, feeding tubes, and other critical interventions.
How does a person under guardianship relate to the physician's order for life-sustaining treatment? How does that work under the guardianship law of Chapter 744?
Under Chapter 744 of the Florida statutes, it governs the appointment of guardians and the powers they hold, including the authority to make medical decisions for their wards. Under this statute, guardians can make medical decisions, but when it comes to withholding or withdrawing life-prolonging treatments, additional safeguards are in place.
What happened in 2023 regarding that, regarding those pursuant to the Florida legislature?
In 2023, the Florida legislature added Section 744-4431, which specifically addresses the scenario when a guardian wishes to withhold or withdraw life-sustaining care. In these situations, the guardian must petition the court and provide clear evidence to support the decision. While guardians under Chapter 744 have broad authority, Section 4431 ensures that the decisions involving life-ending treatment undergo judicial review to protect the ward's rights and well-being.
So, how does a post order intersect with guardianship?
When a ward lacks capacity, the guardian may help facilitate the completion of a post form. However, the guardian cannot override statutory protections, especially when the post includes decisions to withhold life-sustaining treatment. If the post involves such measures, the guardian must first petition the court for approval under Section 744-4431.
Okay, let's talk about court-approved medical orders.
When seeking court approval for life-ending decisions, the guardian's petition must include the ward's prior expressed wishes or any existing advance directives. Medical testimony supporting a terminal or end-stage condition, clear and convincing evidence if no prior directive exists, notice to all interested parties, including Veterans Affairs, when applicable. Once the court grants approval, the post becomes legally enforceable, aligning with the ward's substituted decision. Otherwise, a court petition is required. However, if the ward is terminally ill and is an inpatient without objections, the guardian may act without court approval. These obligations ensure ongoing oversight and safeguard the ward's interests throughout their care, including end-of-life decisions.
Well, what are some of the statutory safeguards and provider protections? In other words, those that would make the decisions.
Post forms automatically expire after 1 year or upon completion of the addressed treatment. At any time, a post can be revoked by the ward, if capable, or by the guardian. A new post form will automatically revoke the previous one.
Okay, let me ask you, what happens if the post conflicts with a DNR or some other prior, say, for example, a POA? Who wins?
If there is a conflict between post and another advance directive, Florida law gives precedent to the most recently signed document.
Aha, so the first one is the one that, or the last one is the one that overpowers. So now let's talk about immunity. What if a healthcare provider gets it wrong? For example, they don't act quickly enough to make sure that the wishes of the patient are carried out.
It's a good question. Healthcare providers acting in good faith in compliance with a valid post are protected from civil or criminal liability that ensures they can carry out these critical decisions without fear of legal consequences.
Are there different requirements for minors who have post orders? I'm assuming that adults and minors are treated the same.
Yes, there is a difference.
Aha.
For minor wards, any post order to withhold life-prolonging treatment requires dual physician certifications and must be signed by the minor's legal representative.
Aha, I see. Now, well, why don't we just focus now on a client who may not want all extreme measures to be used in an end-staged illness. What do post orders provide?
Florida law emphasizes that guardianship statutes should prioritize the welfare of the ward as outlined in Section 744-652. This aligns closely with the goals of POLST to uphold patient dignity and respect the ward's wishes, even when they are no longer able to communicate those wishes. Court decisions, like in re guardianship of Browning, affirm the constitutional right to refuse prolonging treatment, reinforcing ethical foundations of guardianship and POLST.
You know, when we come to that in class, you might just wind up being called to go ahead and recite the facts as well as the holding of In re Browning. Let's talk some more. Can you think of any other examples that might illustrate what POLST is all about?
Sure. Let's take the example of Mrs. L., a ward diagnosed with late-stage pancreatic cancer and lacking capacity. She has no written advance directive, but family members recall that she expressed a preference for comfort care only. Her guardian petitions the court under Section 744-4431. With supporting medical testimony, the court approves a POLST form directing only comfort measures and a DNR order. The guardian provides the approved POLST to the hospital, guiding clinicians in delivering care consistent with Mrs. L's values.
I see. So, in conclusion, what are the takeaways that make having a POLST, important, necessary?
POLST is an essential tool for ensuring life-sustaining treatment respects a patient's wishes, especially in urgent end-of-care life situations. In Florida, however, its use by guardians is carefully regulated by Chapter 744, particularly Section 4431, which mandates judicial oversight for life-ending decisions. This oversight, combined with the clarity provided by POLST forms, ensures that patients' autonomy is respected while also safeguarding their interests in their final days.
Well, Mercedes, thank you very much for your research and for coming to talk to us about physician's orders for life-sustaining treatment. See how fast I said that? I don't think I can say it 3 times. Physician's orders for life-sustaining treatment, or POLST as the acronym calls them. To those of you who are watching and listening, or both, we thank you for your time, and we hope that this podcast was helpful. This podcast is for educational purposes and not intended to provide legal advice. You should contact a licensed member of the Florida Bar to discuss your particular situation, and don't forget to like and subscribe to this podcast. Remember that you can find the Aging Smarter podcast on Senior Resource Alliance website or wherever you get your podcasts. I want to go ahead and at this point thank our Emmy-winning showrunner, Art Miles, and our producer of this section, Annie Rodriguez Newburn.